Imagine the Supreme Court striking down a president's, defining national security policy.
Right.
And the response isn't a legal appeal, it's just a total rejection of the court's right to even judge the case in the first place.
Yeah, it's wild.
Right. Today, we are looking at a scenario where the ultimate referee of American law is essentially told to just step off the field entirely.
Yeah.
We're stepping into this massive constitutional showdown between the executive branch and the Supreme Court, and we'll be exploring arguments that really challenge how we understand the very hierarchy of American law.
It is a profound philosophical clash. I mean, we aren't just talking about a standard disagreement over, a trade policy or a tax rate.
Right.
We're talking about a fundamental dispute over who actually holds the ultimate reins of power in the American system, how that power should be constrained, and whether our modern legal structures have just entirely lost the plot.
Welcome to today's deep dive. Our mission today is to unpack a highly critical, deeply fascinating perspective on a hypothetical but very specific Supreme Court ruling dating to early 2026.
Yeah, early 2026.
Exactly. This ruling struck down the Trump administration's tariff policy. And our source for this exploration today is an excerpt from a book called The Legal Philosophy of the Common Law by author Young Kang. Specifically, we're looking at a chapter titled Case Study 3. Where exactly do the problems of the U.S. Supreme Court lie?
It's a dense text. And I got to say, it pulls absolutely no punches when it comes to critiquing both the judicial branch and, well, the foundational structures of modern global economics.
Yeah, it really goes there. And just as a quick heads up for you listening, this source material takes highly controversial, intensely political stances. It touches on really polarizing debates about the Trump administration, the authority of the Supreme Court, and deeply contested theories of global trade.
Very deeply contested.
Right. So as your guides today, our job isn't to take a side or endorse these claims. We are simply here to map out the how and why of the author's logic so you can examine it for yourself. We're just here to help you navigate the arguments.
Exactly. Impartiality is key here.
Okay, let's unpack this. Before we can really dive into the author's philosophy and his overarching, anger at the system,
Oh, there's definitely anger.
we need to know exactly what he's responding to. So can you lay out the basic mechanics of the court case that triggered this whole critique?
Yeah, absolutely. So the author centers his critique on a timeline of events that begins with a Supreme Court hearing on November 5th, 2025.
Okay.
The core issue being debated there is the legality of massive new tariff measures. These were introduced under what the text refers to as the Trump administration's 2025 New Deal.
Right, the 2025 New Deal.
Right. So fast forward a few months to February 20th, 2026, and the Supreme Court hands down its ruling, and by a 6-3 vote, the justices upheld a lower court's decision, effectively striking down the administration's entire tariff policy.
Wow. And what was the actual legal mechanism behind that decision? Why did the court say the administration couldn't do this? Because, presidents use tariffs relatively frequently, right? What made this one different?
Good question. So the majority of the court ruled that the administration, and I'm quoting the text directly here, exceeded its statutory authority under a specific law. That law is called the 1977 International Emergency Economic Powers Act.
IEBPA.
Exactly, the IEPA. To understand the ruling, you really have to understand the IEPA. It's a law designed to give the president broad powers to regulate commerce, but specifically during unusual and extraordinary national emergencies.
Like wartime or...
Right. It allows the executive branch to freeze foreign assets or block certain financial transactions. But the administration tried to use this specific statute as the legal justification to implement really broad, sweeping tariffs.
Ah, I see.
Yeah, the court essentially looked at that and said, you are trying to stretch this specific emergency law to do something it simply does not give you the power to do.
And the author provides some really illuminating details about the pushback from specific justices during that November hearing. It wasn't just like a blanket rejection of tariffs. They had very pointed mechanical concerns about how the power was being wielded.
They really did. Justice Barrett, for instance, she zeroed in on the literal text of the IEPA.
Right.
She challenged the administration, asking where exactly the phrase regulate imports in that 1977 law authorizes the imposition of massive new monetary tariffs.
She wanted the specific mechanism.
Exactly. And she found it lacking. And furthermore, she questioned the diplomatic logic of using emergency powers to impose reciprocal tariffs on traditional American allies.
Right, because she specifically brought up Spain and France.
Yes. She questioned how taxing allies fits the definition of solving a national security emergency.
Yeah, that makes sense. And then you had Justice Gorsuch coming at it from a slightly different angle. He was focused on a structural concern known as the non-delegation doctrine.
That's a crucial piece of the puzzle here. The non-delegation doctrine is this principle that Congress cannot simply give away its core constitutional powers to another branch of government.
They can't just outsource their job.
Right. And Justice Gorsuch raised serious doubts about whether Congress even has the constitutional ability to delegate that level of sweeping tariff authority to the president in the first place.
Wow.
His worry was that allowing the IEPA to be interpreted this broadly, it would lead to a dangerous concentration of legislative power sitting squarely in the executive branch.
Which all culminated in Chief Justice John Roberts writing the majority opinion. And Roberts really hammered home where the power of the purse lies in the Constitution.
So he definitely did.
The text notes that Roberts stated the Constitution very clearly vests the power of taxation. And he explicitly included tariffs in that definition in Congress under Article 1, not the executive branch.
Right.
The quote the author pulls from Roberts is pretty definitive. He said, "The framers did not vest any taxing power in the executive."
That's a strong statement.
Yeah. Very strong. Roberts emphasized that a president cannot claim unilateral tariff authority of an unlimited amount, duration, and scope without incredibly clear, specific authorization from Congress.
So they need explicit permission.
Exactly. So the Supreme Court is essentially saying the president is trying to use a Swiss Army knife, the IEPA, to chop down a giant redwood tree, when the Constitution clearly states that only Congress holds the actual axe.
What's fascinating here is that your analogy perfectly captures the court's logic, but it sets up exactly what author Young Kang is trying to dismantle.
Oh, really?
Yeah, Kang argues that when it comes to the border, the president shouldn't even need Congress's axe. His central counter-argument is that the Supreme Court fundamentally misunderstands the nature of the tool.
Okay, how so?
Well, the court says tariffs are taxes, right, and therefore belong to Congress. But Kang says tariffs and taxes are entirely different species of economic policy.
Let's dig into that because this is his first major rebuttal and it requires redefining some very basic concepts. He brings up this foundational British constitutional principle, no taxation without representation.
Right.
We all learned that in grade school. The idea that a government can't just take your money without you having a voice in the legislature. But Kang argues that this principle only applies to domestic citizens and domestic businesses.
Yes.
He's talking about internal levies like, a sales tax or an income tax.
Kang argues a tariff fundamentally breaks that domestic mold because the payer of a tariff is not the general domestic citizenry. According to his economic framework, the tariff is paid entirely by importers.
By the importers themselves.
Exactly. And who are importers? They are commercial entities that voluntarily choose to bring foreign goods into the country to make a profit.
Okay, voluntary is the keyword there.
Because that action is voluntary, Kang insists it is an entry price, like a toll booth at the border, not an inescapable domestic tax imposed on citizens.
Right. So if tariffs are just toll booths meant to protect domestic workers, that puts Kang on a direct collision course with the modern global economy.
Oh, yeah, absolutely.
And that's exactly why he views the World Trade Organization, the WTO, not as a facilitator of peace, but as a fatal economic trap. He says trade between nations should never be prioritized above domestic production, full employment, or industrial security.
Yeah, his stance is intense.
Because of that, he argues that a tariff must exist. It cannot be zero.
His economic philosophy is deeply protectionist. He states that a zero-tariff regime effectively erases national borders and trade. He believes a hollowed-out American supply chain has zero global competitiveness.
Right, because everything is just outsourced.
Exactly. And therefore, foreign goods must pay a necessary calculated cost to enter the market. And importantly, he argues these tariffs must be bilateral, meaning negotiated one-on-one between two sovereign nations, not multilateral agreements managed by some global body.
Which brings us to his absolute takedown at the WTO. I mean, he calls their advocacy for zero-tariff multilateralism the construction of a modern Tower of Babel.
Yeah, that's a vivid image.
But he isn't just name-dropping a biblical story for effect. There is a very specific mechanical reason he uses that metaphor.
Right, he uses it to highlight a systemic failure of communication and structure. The biblical story, the tower construction failed because the builders suddenly couldn't speak the same language.
They couldn't understand each other.
Precisely. Kang argues the WTO fails because member nations don't speak the same economic language. The architects of the WTO relied on Adam Smith's classic economic principles. Larger markets lead to deeper specialization, a finer division of labor, and ultimately higher productivity for everyone.
But Kang says there's a fatal flaw in applying that theory globally today, right?
He argues that Adam Smith's unified market theory only holds true when all the participants share the exact same internal value system.
The same rules.
Yes, if every country playing the game shares the same internal rules regarding, minimum wage, labor rights, environmental constraints, and government intervention, then free trade works beautifully.
But they don't.
Right, when nations don't share those values, the system actively punishes those who play fair.
And he brings in a really concrete historical example to illustrate this clash of value systems. He contrasts Japan in the 1970s and 80s with China today.
This is crucial for understanding his view of modern trade. Kang points out that in the 1970s, Japanese automobiles dominated the U.S. market simply because they were cheaper and highly efficient to produce.
They just made good, affordable cars.
Right, but Japan was operating within a normal capitalist market economy. So over time, that very economic success drove up their domestic costs. Wages in Japan naturally rose. The value of the Japanese yen appreciated.
Okay.
By the 1980s, the natural forces of a free market had forced Japanese production costs to converge with American costs. The market corrected itself organically.
But he argues that China's accession to the WTO fundamentally broke that natural correction mechanism.
Because, according to Kang, China operates a state-controlled, non-market economy. The government monopolizes the core resources, capital and land, by systematically suppressing the costs of labor, energy, and environmental protections through state mandates. They artificially keep their prices low indefinitely. But they don't have that organic rise in costs. Exactly. They never experience that natural organic rise in costs that Japan did. Kang argues this flavor of state capitalism allows them to capture global markets at artificially deflated prices.
Wow.
They're basically exporting their domestic distortions and rendering organizations like the WTO completely defenseless and dysfunctional.
That's a huge claim.
If we connect this to the bigger picture, if Kang believes the WTO is broken, that multilateral free trade is a dangerous myth, and that state-sponsored economic warfare is the reality, then the nation-state has to defend itself.
Right.
And if tariffs aren't just domestic taxes, but actually vital weapons of international trade and border defense, whose job is it to wield those weapons?
Well, having established his view that tariffs are international trade mechanisms rather than tax revenue, he shifts the discussion to the core of foreign affairs. And in the American system, the undisputed master of foreign affairs is the president.
Yep. Kang argues that the Founding Fathers purposefully chose to establish a system with an independent, powerful executive branch. They explicitly rejected the idea of copying Britain's parliamentary system, where the prime minister is deeply entangled with and beholden to the legislature.
Because he argues the founders did this because they knew a young nation needed a leader who could act decisively, someone who could steer the country through what he calls the fog of endless congressional debates.
The fog.
I love that phrase. Congress is designed to be slow, deliberative, and cautious. But foreign affairs, especially in a distorted global market where economic attacks happen in real time, they require speed and decisive action.
He views tariff policy as the president's absolute most vital diplomatic tool. Without the ability to unilaterally wield tariffs, he argues the president's hands are tied at the negotiating table.
Why?
He even throws in a reference to George W. Bush and Dick Cheney, presenting a stark dichotomy. He implies that without economic weapons like tariffs to force diplomatic outcomes, a president might be forced to rely on actual military force to resolve international disputes.
Wait, I need to pause on something he brings up to justify this aggressive executive power. He claims that the Trump administration's 2025 tariff reforms resulted in approximately $18 trillion in new investment commitments from multinational companies within the U.S.
Yeah, that's the number he uses.
$18 trillion. I imagine anyone listening to that number is going to have their eyebrows raised. Is Kang using that staggering figure, whether we verify it or not, to essentially justify the means argument for overriding the Supreme Court?
That is precisely the pivot he makes. He uses that number to hammer home his point that continuous capital investment is the only sustaining force behind a nation's prosperity.
Okay.
He's saying, look at the results. The policy objectively works for the American worker. But the Supreme Court didn't look at the results. They looked at the statute.
Right. They looked at the IEPA.
Which brings us to perhaps his most radical legal argument in the entire text.
Yeah, he moves from economic theory into deep legal philosophy here. He argues that the United States is fundamentally a common law nation, having inherited that tradition from Britain.
Yes.
However, he believes that the modern proliferation of statutory law is actively eroding the true spirit of the common law system.
To understand his critique, we really have to clarify the difference between statutory law and common law. Statutory law is like a rigid recipe written by a committee.
Okay, a recipe.
It's the written codes passed by Congress, like the IEPA. A judge applying statutory law is supposed to follow the exact measurements written on the page, regardless of how the dish turns out.
Right.
Common law, historically, is much more fluid. It's based on precedent, custom, and the practical realities of the community. It's more like a chef tasting the soup and adjusting the seasoning based on what actually works in the kitchen.
I like that analogy.
Kang is arguing the Supreme Court is acting too much like rule-following bakers and completely abandoning their role as pragmatic chefs.
Here's where it gets really interesting, and honestly, where the friction in his argument reaches its peak. Because to fix this supposed erosion, Kang actually tells the 9 Supreme Court justices to step away from their legal text.
Yes, he does.
He literally asks them to act like a common law jury. He says they should use their God-granted conscience to judge if the president's policy makes America prosperous rather than looking at rigid statutes like the IEPA.
Yeah.
Isn't that asking the highest court in the land to explicitly ignore the written law?
Your pushback gets to the very heart of the legal debate happening here. What you were describing, following the written text of the law above all else, is textualism.
Textualism.
Chief Justice Roberts and the majority applied textualism in this hypothetical ruling.
Yeah.
They looked at the IEPA and said, the text doesn't give you this power, end of story.
They focused on the legality of the process, not the economic outcome.
Exactly. But Kang is advocating for a form of moral pragmatism rooted in an older, almost romanticized view of the common law jury.
How so?
In his view, a historical jury doesn't just read a statute. A jury looks at the totality of the situation, the intentions, and the real-world impact, and decides what is just and what serves the community's survival.
Okay, so he wants them to look at the big picture.
He is essentially demanding that the Supreme Court elevate the practical national security outcomes of a policy above the technical statutory constraints placed on the executive branch by Congress.
He wants them to judge the results of the policy. And if you are asking judges to ignore statutes in favor of political outcomes, I mean, you're making a massive foundational statement about the hierarchy of law itself.
King spells this out explicitly in his conclusion. To justify this hierarchy, he draws on the ancient Greek polis, the city-state.
Polis, yeah.
He observes that in ancient Greece, laws didn't just appear out of thin air. They were written by people who first had to secure a political mandate, often rooted in the raw survival of the city.
He argues that the political decision-making, the actions necessary to secure the survival and prosperity of the state, always preceded the luxury of lawmaking.
Exactly. In his view, the raw survival-based political decisions of a nation create the foundation. Laws are just the house built on top of that foundation.
Okay, so foundation versus house.
Therefore, if the rules of the house, the statutes, threaten the structural integrity of the foundation, meaning the nation's economic survival, the foundation must take priority.
Wow.
From that historical observation, he derives his ultimate overarching thesis statement. Law is inferior to politics.
Law is inferior to politics. It is a profound and highly controversial claim. He is arguing that the American system of separation of powers, specifically the creation of an independent executive branch tasked with foreign defense, is itself a macro-political structure that sits above any individual statute passed by Congress.
That's his argument in a nutshell.
So what does this all mean for accountability? Like, if the president's executive authority is above the statute and must remain intact to fight economic wars, and the Supreme Court is supposed to just act like a jury and let him do it, how is the president checked? Where is the balance in Kang's system?
Kang's answer is that the corrective mechanism for executive authority shouldn't be the courts stopping a policy in real time.
Okay.
He believes that using injunctions to halt foreign policy paralyzes the nation. He argues the only valid constitutional check is retrospective.
Meaning after the fact, after the damage or the success is already done.
Precisely. He argues that if a president's policies fail, if these massive tariffs actually cause economic ruin instead of the promised prosperity, The voters will recognize that failure and vote the president out of office after his 4-year term.
At the ballot box.
Elections, in Kang philosophy, are the proper ultimate process of political correction, not judicial injunctions. He truly believes the political mandate from the voters supersedes the rigid legal interpretations of the courts.
And he concludes the chapter with a prayer, right? Asking God to grant wisdom to the Trump team to find alternative measures to maintain their tariff policy despite the Supreme Court's ruling. And he ends with a final plea: may God preserve America.
Yeah, that ending really highlights the absolute existential stakes he attaches to this debate.
It really does. He frames this not just as a, dry legal dispute over trade law, but as a literal battle for the survival of the nation in a hostile world.
It's a worldview where economic security is synonymous with national security, and legal formalism is viewed as a dangerous obstacle to both.
Well, to bring all these threads together for you, the listener, we've explored Young Kang's passionate, multi-layered argument today. We've looked at his economic belief that tariffs are essential foreign policy tools to defend borders, not domestic taxes bound by the power of the purse. We've examined his view of a powerful, independent executive that needs to navigate a distorted global market without being bogged down by slow congressional statutes. And we've unpacked his overarching philosophy that political mandates and national survival should supersede rigid legal interpretations by the courts.
This raises an important question, though.
Yeah.
Kang views elections every 4 years as the ultimate appropriate check on executive power. But traditionally, the Supreme Court's role has been exactly what he despises: to act as a real-time brake on authority, preventing damage before an election cycle can even happen.
That's true.
That friction between real-time legal checks and retrospective political accountability is largely considered a feature, not a bug, of the American system designed by the founders to prevent tyranny.
And that tension brings us back to where we started. If the rules of the game are suddenly up for debate, how is the game played? Which leaves me with a final thought I want to pose directly to you as you digest all of this.
Go for it.
If we were to adopt Young Kang's view that executive actions in foreign policy should largely be immune from judicial statutory review and only judged by voters at the ballot box every 4 years, what happens to international relations and global markets during those 4 years if a president makes a catastrophic miscalculation? How much economic whiplash can a global system actually handle while waiting for the next election cycle to correct the course? Thank you for joining us on this deep dive. Keep questioning the information around you, and we'll see you next time.